This time, I'd like to introduce my colleague, Janet Cho. Janet focuses her practice on intellectual property counseling, prosecution, and litigation. She represents clients in trademark, trade dress, advertising, domain name, and copyright matters. She advises both individuals and businesses with registration and management of intellectual property assets, as well as licensing such assets. Janet, take it away.
Thank you, Farhad, and thank you everyone for your time today. I'm really excited to talk about this subject. And before I start, I wanted to make some preliminary comments. One is that the title of this presentation is Risks and Recommendations for AI-Generated Content. And like Micah did during his presentation, I want to clarify that or distill that a little bit because that's pretty broad. What I will be focusing on is the intersection of AI-generated content and copyright law. Specifically, what is the United States Copyright Office's position and treatment of content that is generated by AI, either wholly or partially, because there have been some relatively big sea changes in that area. And also, I may do a little bit of moving around in the slides, but we will be covering all of the subject matter in the slides. So next is, thank you. I apologize. My laptop is hesitating a little bit, but it's just now caught up. So we will be discussing these topics. And I think generally what I'd like to do is help people understand a little bit more about AI. The comments that I've generally received from clients and others out in the public about AI is along the lines of, I never use AI and I don't like AI. And sometimes people say that after not having tried AI. I also hear very often, oh, my company doesn't own any intellectual property, or I don't have any intellectual property. So, and it's been my experience that that's generally not the case. So I wanted to do some investigating and maybe busting of mythology when it comes to AI and copyrighted works. And to start, we have a bit of a poll here. So just wanted to ask, and I think this is a pretty easy question, how many out there have ever used machine learning or AI, an automated process? So I will give everyone a few minutes to respond and just see what we come up with. And I think it'll be interesting to see how prevalent among our listening audience AI is, so that, and I'd be interested to hear as we go along, if people have questions, what people's thoughts are. And so we just have a few more seconds for poll, so feel free to chime in. And also, there are many different kinds of AI or branded AI platforms. So any type of AI that you might have used, feel free to answer based on that. So it looks like a majority of people, over half, have used AI, which is great. My experience kind of goes against that. I usually encounter people who have not used AI. So I think we have a relatively sophisticated listening audience. So before we start, I thought it might be helpful. I provide these links for those who haven't tried AI. These are just some links to AI platforms. The first is DALL-E, which is a platform that you can use to generate images and graphics. So you can instruct the platform, or you can instruct the tool to, create an image of a sunset or horizon or what have you. And then the second link is to ChatGPT, and you can give that instructions. So, and if you've used it before, feel free in the questions or in the comments to recommend platforms that you have tried that you really enjoy. But these are just to get us started. So with that, I wanted to, before we get into the merits of the slides, I wanted to do some defining, because what we're discussing has fairly large concepts attached to it. So AI and copyright. So what are those things, and perhaps why do we even need to discuss them or have care about them right now in the landscape of all that's going on in technology? So AI, for those who don't know, is essentially the simulation of human intelligence processes by machines, particularly computers. And that's not my definition. It's a general definition I located, which I thought was very helpful. It kind of gets to the heart of what AI does. And how AI works is that it essentially ingests voluminous amounts of information, and how it receives that is through what we call, and what some of you may have heard of as, training data. So you input all of this information to train your AI platform, and what the platform will do, or what the tool will do, is essentially go through all of that data and try to locate and make connections, correlations, patterns, and they use this information to essentially assist you and provide the outcome that you've asked it to undertake. And right now, AI, I think it's improving every day, but it's already made significant advances since when it first became, I think, widely available. But it can do things such as, have a conversation with you. It can create images. It can summarize things, write music, all of those kinds of things. So one example I like to give when someone says, I don't think I've ever used AI, or AI is not a part of my life. And I think someone mentioned this earlier, maybe during the first presentation, that if you are engaged, say, in an e-commerce transaction, you want to order something from your favorite store, very often there'll be a little chatbot that appears, or a little sales representative chat, and they will ask you, can I answer any questions about this product? What can I do for you? And that chatbot can be, and very often is, running on AI, or partially operated by AI. I don't want to speak for every chatbot out there, but when you ask that chatbot, can you tell me, how much such and such costs? What that chatbot is learning through your dialogue with it, it's learning how to have a lifelike conversation with someone. And that's how AI gets better over time, is through these repeated engagements with people. So one thing I want to emphasize is, and hopefully this presentation will help clarify, that AI actually does exist and is running perhaps in the background of a lot of the engagements we have, whether they are with, businesses that we work with, clients that we work with, or even just personal engagements for shopping or what have you, doctor's office appointments. There's very often an AI component to it. So I think it's helpful to kind of think about what might be the risks and benefits, both inbound and outbound, when it comes to engagements with AI. The other thing I'll emphasize is AI is dynamic, so it can learn because it focuses on acquiring data. It can get better on turning what it receives as trainable information into actionable outputs. And it operates through a set of rules, which I think everyone has heard of, algorithms. So it uses these algorithms to go through a series of step-by-step instructions on how to complete a task. It can also reason. So it can focus on, the AI platform can focus on choosing which particular algorithm might be the proper one to reach the outcome that you've asked it to attain. It can also self-correct. So it can fine-tune, or it can sort of go through the algorithmic decision-making process and make a different decision based on whatever the issue is, and sort of make corrections going forward. And it can also do things that are creative. And I use creative in quotes, meaning it can generate music, it can generate text, and it can do this in new and different ways from prior instructions it has received. So AI is pretty powerful. And I think that's a lot of the reason why you may have, clients or other businesses, or perhaps vendors, that want to use AI for whatever is the part of the relationship that you may have with this particular client or business. The other side of this conversation is how AI can affect content that you would like to see protected or are considering being protected under copyright law. And here is just a brief mention of the United States copyright statute. Copyright protection is an elaborated right in the United States Constitution, and there's also a Copyright Act. And the intention of the Copyright Act is to reward authors for the creation of original works. So very often I will hear, well, we don't really, as a business, we don't really engage in that. So I would encourage everyone to think about some of the things that you do, either to operate your business on a daily basis or to promote what you're doing, to promote your product or service. So for example, if you have a website associated with your business, you likely have a copyrightable work right there. If you have data that you collect and you maintain that data in a particular pattern or arrangement, you may have some copyrightable work. So, and I could go on, and that's just to show you that even things that maybe on a daily basis we consider fairly rote and necessary items to just keep our business going, there may be some copyright protection involved or copyrightable works involved. And just to kind of provide some context, what ultimately is a copyrightable work is something that is original and fixed in a tangible medium, meaning it's non-ephemeral, and it can be saved on a computer, written down on a piece of paper, or captured on a canvas. So it can't be smoke signals, it can't be things written in sand that are going to be washed away, because those cannot withstand sort of the elements. But things such as photographs of smoke signals you make, or a painting of something along those lines, that is likely to be protectable if it meets all of the other standards for copyrighted work. So with that, I wanted to pivot a little bit, because if you have some work that you're thinking of perhaps filing for at the Copyright Office because it's very important to you, what are some of the considerations as a starting point? And one thing I wanted to begin this conversation with is, and this is a question that kind of comes up a lot in just general conversation, is does the Copyright Office expect that what you file for to protect, or something that you're seeking to register, is there a human created component to it? And I will say that I've been involved in a fair number of copyright applications and asserting copyright rights. And up until recently, I've never really had to think about, is the work that my client is asking me to protect, is it human created, or how much of it is human created? But now that's something that I certainly need to contemplate as we think about registering the work, and as AI becomes more of a common tool used to create work for authors. So one practical point is, if you have a work that you've created for your business or personally that involves some element of AI, let's say a few graphic elements or pictures that you've used AI to create, that you've incorporated into your work. One is you want to use the standard application, and there are different kinds of applications before the US Copyright Office, but you want to use the standard application. And basically there is a human created authorship component in copyrighted work. And I'm going to discuss that in greater detail, but as a starting point, whatever you seek to register, whether it's been created by yourself or maybe with 12 other people, however that's done, there has to be an element of human authorship involved in the work. And one of the things that I wanted to include, just as a funny point, and I think for those of you who've used AI, you've probably seen this, at this stage, is there a distinction between what a human might create and what AI might create? And so I just found examples of jokes written by AI, and you can see, why did the new ant say after a dog it was a pirate? Why did the monsters change the light bulb and a cow the cough? So clearly it's nonsensical. And as you train AI, it's going to get better at resolving some of these nuanced issues, such as such as jokes and things like that. But I think part of the issue with the Copyright Office expecting that there's human created authorship, in addition to all of the other issues, such as the purpose of the Copyright Office in the first place, is I think they want to see a certain level of, perhaps quality is the best word, or substance, that they want to make sure that there's integrity in the works that they are registering as an initial consideration. So how this plays out in real life, and this just happened fairly recently, there was an author, Christina Kashtanova, and she had authored a comic book called Zarya of the Dawn, and she listed herself as the author, and she filed an application with the Copyright Office in September of last year. And I'm not entirely sure if she did this she had filed other applications and she just went on her usual course and just filed as she always had, or if there was any intent to, not disclose the fact that she had used AI, but she had essentially used an AI platform to create certain graphic images that she included in her book. So she filed her application, and I guess everything went smoothly, and the United States Copyright Office registered her work. However, in October of 2022, which is essentially about a month after she filed her application, which is pretty quick action actually by the Copyright Office, she was informed by the Copyright Office that it intended to cancel her registration after she had made statements on social media that she had used a particular AI platform to create the work. So I will stop there only to say the facts of this case are pretty remarkable. For those of us who practice in intellectual property or are familiar with the actions of the Copyright Office, I have never, and maybe some of you have, but I have never been on the receiving end of a notice from the Copyright Office that it intended to cancel a registration. I gather that's relatively rare. And also the fact that the Copyright Office acted after seeing material on or seeing content on social media is also pretty memorable, a pretty big deal. And this kind of goes to what I think others have talked about when it comes to social media and statements that you make online. You probably want to be very careful in terms of what you discuss generally on social media, just as a personal habit, but also when it comes to your work that you're seeking to protect or enforce. Even if you're not looking to register it with the Copyright Office, you just want to talk about it and promote it, you probably want to think about how you want to contextualize your work in the context of promotion if it has AI content, whether that's a lot or a little bit, and however that's defined in relation to your work. You want to be careful, because at some point, if you intend to enforce the rights in your work, or you feel as though you need to defend it, and some of which was what I'll talk about later, is it may come into play if someone says, well, you've used a fair bit of AI, how can you say that you're the author? How can you say your work is original? So this author had her work canceled or threatened to be canceled. So each side had their arguments in terms of why they were right. And the author's arguments were along the lines of what you would expect. She alleged that she used AI merely as an assistant, maybe just the way you might use a reference book, I suppose, that she basically authored every aspect of the work, and the text in the work, separate and apart from the images that she derived from AI, was itself copyrightable, and that the work as a whole, as a compilation, the text, the images, how she arranged everything, how she made any stylistic flourishes or what have you, as a whole, the work should be granted registration and should be protected by the Copyright Office. Copyright Office's rejoinder was, you're not the author of the images that you included, that you used AI for, that the AI was the author. And you didn't actually make any substantive changes or transformative changes to the images that you included that were based on AI. You just directed AI to make this photo, and then you just, uploaded them or what have you to your book. So these are kind of where the rubber meets the road in terms of people, authors seeking protection and the Copyright Office's pushback. So the ultimate outcome was that the author's AI generated work was explicitly excluded. She was granted registration, or she was allowed to have a registration for her work, but the AI generated work was excluded, and her book was recognized as what we called an unpublished literary work, and she was granted protection for her text and the selection and arrangement and coordination of the text, and the protection also extended to the artwork generated by AI in terms of its arrangement, but the underlying images themselves were not granted copyright protection, which I think is an expected outcome from the Copyright Office. There's probably going to be more changes along the way in terms of the Copyright Office's treatment of content such as this. I think we're seeing the beginning of the Copyright Office dealing with these issues, but I think this author's work is a really, really good example of how the Copyright Office is trying to deal with this new technology. And as part of, generating artwork, I've included some links to some AI platforms that you can use to generate artwork. And I think that these platforms are pretty common now. I do know of people who, they want artwork for their office, so they'll go to one of these sites and tell it to generate a picture from a trip that they really enjoyed, and then they frame it and put it up in their office. And so I think that these kinds of art AI platforms are certainly helpful in terms of trying to find references if you want to see what something looks like as it's generated by AI. But certainly on a personal level, I think they're also very commonly used. So earlier this year, I wanted to pivot a little bit about where the Copyright Office stands, or get into greater detail on where the Copyright Office stands in terms of its position on AI. So earlier this year, the Copyright Office hosted a summit, or an AI event, and they essentially talked about their position on content that includes material that is generated from AI. And the key points were that whether a work, and I'll just read this because it involves legal precedent, but whether a work has sufficient human authorship falls under the de minimis standard. And it quoted these copyright cases, with the Feist case, which actually is a very famous, well-known, long-standing copyright case, that for works that are to be protected under the copyright right, it has to possess more than a de minimis amount of creativity. So another way to say that is, there is a creativity requirement for works to be protected by the Copyright Office. I would describe that as a relatively low bar of creativity, but there does have to be some creativity. And how that plays out can vary from work to work. One really good example is, and this is a question that I receive, is data, or are arrangements of data, copyrightable? And there's this case, when we're talking about data and, and protection of data, relates to, you may have a gigantic collection of data, and it's really just data that already exists, all of your sales invoices, or how much you pay for your, how many times you've renewed your internet wireless contract, something along those lines. I think all businesses have that kind of rote data available to them. But if there's some creativity, or there is some human selection to how that data is arranged, and it's not just arranged, say, in reverse chronological order, or you've added a few additional data points that aren't necessary to make that data more usable, say for your employees or for your team, then you may actually have copyright protection in data. And so, and I'm speaking generally, because I think every copyrightable work sort of depends on the specifics of itself, but there is a minimum of creativity that's required. And that's one thing I want to emphasize, is that even though the bar is low, you still have to have some creative element to your work. And if it doesn't, then it may not be at least registrable with the Copyright Office. And the other issue, which I will discuss in greater detail, is if your work has any non-human authored content, you have to disclose that, number one. So that's very important. And if you don't disclose that, you might be subject to fines. And again, I will say, when in the past, when I've had a client approach me and say, I have this new, manual, this employee manual, and we'd like to protect it through an application and hopefully registration through the Copyright Office, you have never asked how much of this is written by you as an individual or by human authorship. But I think now that we're in this stage of how common AI is, it's something that, one, we as attorneys that may be assisting clients with registering work have to consider and ask. The other thing I would say is, as a business that's seeking protection for that kind of work, it might be helpful to have some records as to, how much of that work is actually based on AI. And that sounds like and I don't mean to create a burden, but I think it would be helpful if you have that sort of documentation for works that you consider very important that you want to register with the Copyright Office. I'm going to sort of step out of the copyright realm for just a moment and discuss privacy a little bit, only because I think it's really important as we talk about using AI and how it collects data. There will be a presentation later today discussing privacy in greater detail, but I think I would be remiss if I didn't talk about privacy to some extent and how it intersects with AI. So we've already had a discussion about the Federal Trade Commission and its role, but the FTC, and just to give some context, the FTC does have a part to play in privacy and its connection to how AI may be used. And how it derives its authority is that, one, it has fairly broad investigative and enforcement powers and rulemaking powers. And from Section 5A of the FTC Act, it provides that unfair or deceptive acts or practices in or affecting commerce are unlawful. So that's really the FTC's role, is to make sure that there aren't, in addition to its other responsibilities, is to make sure that there isn't, deceptive or unfair practices affecting commerce, and to tie that to AI, to make sure that there aren't individuals or businesses who are using AI to engage in these deceptive business practices. And a practice is unfair if it causes more harm than good. And what you want to analyze in that sort of scenario is whether the practice is likely to cause substantial injury to consumers that is not reasonably avoidable by consumers and not outweighed by countervailing benefits to consumers or to competition. So really just sort of assessing, weighing the harm to the benefit in relation to something that may be potentially unfair. And how that pertains to AI is that the FTC wants to make sure that if you are engaged in the business of AI, that you're not using it to engage in behavior, not certainly that's unfair or deceptive, but also harming consumers in specific ways. And I want to make a reference, and I can share this if those of you listening want to have a copy of this, but the White House at the end of last year put out an AI Bill of Rights. And it's a fairly long document, and it's a best practices type of document. It's not a law, it's not enforceable, but it does talk about using AI to gather personal information for harmful purposes, using AI to sort of create what we call deep fake or false images to lure people into making purchases that are not good for them. Things like that. There are other issues, not using algorithms to discriminate against individuals on particular grounds, but that's one of the direct ties to the FTC, is that making sure that your AI use is not engaging in bait and switch activities, or creating a situation where the transaction is not transparent, so that consumers will be mistaken into engaging into a transaction that is actually harmful, or that is not entirely transparent from the beginning. Excuse me. In addition to the FTC's privacy enforcement power, I think this is probably known to many of you listening, that individual states also have privacy laws. And so, unlike, say, the EU, where there is a EU-wide privacy directive, which some of you may have heard of, the GDPR, we do not have a national unilateral privacy law across the country, or a federal privacy law, I should say. So we have a system of state privacy laws. I think there are many similarities among these privacy laws, but why privacy is important in the context of AI is because AI is being fed information, and then it's going out and making connections to that information. What can potentially happen is that information such as sensitive personal information, health information, credit card data, anything like that could potentially be disclosed and sort of put out into the stream of this algorithmic process. And so there are concerns that because AI is an automated system, that it may not be good at discerning, and probably is not very good at discerning sort of what is potentially personal information that it shouldn't engage with. So I think that's something to think about, both in the inbound side or the outbound side. So if you are putting information out there to train AI, please make sure that that is information that is information you have a right to disclose in that manner. And I know in a prior CLE session, we spoke about privacy policies. If you are using AI from a business perspective, making sure that whatever you're putting out into AI, or perhaps using as training information, does not violate the privacy practices that you have posted for your consumers or your partners. And also making sure that that you're following through on, if someone says, look, I don't want my information to be, you can use my information to process my credit card transactions, but I don't want my information being used for this automated decision making by AI, or please just don't use my personal information at all, that you're responding to those requests, because most state laws provide for user rights, and those rights include the right to opt out of use of their personal information, the right to opt out of automated decision making, the right to receive information about what it is that you're doing or who you're sharing information with. So these privacy laws try to put a lot of transparency into the hands of the consumer, or the subject of whose information is being used. And so I just want to emphasize that when you're using AI, you make sure that you are just being careful about what information you're putting out there, what information you're receiving, and how you use that. And also just, again, making sure that you're abiding by your privacy policies, your terms of service, or any other agreements that you may have with your customers or your partners, that you're abiding by all of the representations that you've made regarding data. And before we go on, I wanted to, I think we have a poll question coming up, so I will give everyone a few minutes. And I think this is a fairly easy question because I think I gave you all some part of the answer, but from which part of the FTC Act does the FTC derive its authority to regulate businesses offering and using generative AI? And I will give everyone a few minutes. And I will say that there has been a lot of controversy around how AI can be used to create maybe sales or product and service scenarios that are extremely misleading. I think we could probably have a podcast or a CLE session entirely devoted on controversies relating to or provocative incidents involving AI. And so that's essentially what the FTC is trying to protect against, is making sure that because AI can do such a good job with text and things like that, that people are protected from unfair practices. And so 86% of you chose Section 5A, which is actually absolutely true. It is Section 5A that grants the FTC the power to regulate or enforce against unfair and deceptive trade practices. So one thing I will say is that I think there is a misperception, perhaps, that AI is relatively new. And I think in the sense that it's widely available to us as general people who don't have a specific purpose for it, that's likely to be true. But generative AI has actually been around for a fair bit of time. And I think many of you have probably heard of the artist Harold Cohen. He wrote his Aaron program in 1973 to produce drawings. So it's the AI tool, the AI ability has been around for several years. But I think that we as the public, and I certainly think the Copyright Office and other similar agencies, are now just catching up to how do we deal with content, or how do we deal with material that includes AI. And kind of going to the training piece of this, there was a case where an illustrator at Disney had found that her art style had been cloned in an AI experiment by an engineering student in Canada. And the student essentially took the illustrator's pieces and trained a AI tool to reproduce her style. I'm not familiar with the nuances of the style, but I think my understanding is that it's fairly memorable. And so the student essentially used AI to replicate the distinctive style of art of this particular illustrator. And the illustrator reported feeling that her work had been stolen, that her work had been incorporated into without her knowledge and without her permission. And why this is important is that if you are an author of a work, or you are the owner of a copyrighted work, you own all of the exclusive rights associated with that work. So in the United States, the default position is that if you authored something, you own all of the copyright rights associated with that. That can be changed by agreement. If you have an assignment or a work for hire agreement, it's possible that someone other than the creator can own all of the copyright rights associated with that work. But if you are the owner of a copyright right, then you can control the exclusive right to replicate that work, to sell the work, to display the work, and also to make derivatives from the work. And so if any of those actions are taken without the copyright owner's permission, then there's a potential for infringement. And typically why copyright rights are so valuable, especially for creative content, is that people and businesses that own these rights are looking to license for royalties the underlying copyrighted work. Now, I'm not sure that that's where this illustrator was necessarily going. And I don't know that I was not aware that the student had done this with any negative intent, or literally to sort of just copy her style for their own commercial gain. But I do think that this sentiment where parties are using another party's work, artistic or otherwise, to train AI feels like a theft, feels like an unauthorized or a misappropriated use of their work. And if we have time, there's a case that's recently just been filed in September against OpenAI by a group of writers, kind of going to this point. But I bring this up to say these are some of the risks that can arise when you're talking about AI. You may think that, well, I'm going to go online and I'm going to look for and I'm going to find a writing style, or I'm going to find an illustrative style that I really like, and I want to train my AI to replicate that because I want to use that for a marketing piece I'm putting together for my business. And it's going to make, my AI platform, run really smoothly, and it's going to be able to generate this work, and it's going to be great. Otherwise, I may have to, invest in having an artist or someone else try and replicate this, but now I can do this quickly and fairly cost efficiently. So that's certainly a gain for you as the potential user. But when you have the originator of the creative content on the other side saying, I feel like my work was used without permission, then you have a potential conflict arise. And that's not to say that that other party will sue. It's not to say that, they'll send you some sort of cease and desist letter, but the discontent or the objection from the creative content owner may create a potential risk or liability that makes using certain kinds of material for training AI to be a risk or a liability. So it's definitely something to think about. I wanted to also note, and that we kind of discussed, I mentioned this previously when we were talking about the FTC side of things. Additional issues with risks is just making sure that, first and foremost, I think that right now there's a huge interest in AI and, we have to use AI. We have to get on the AI bandwagon. And I think that that's a great, instinct to have. However, you want to think about, okay, why am I using this? Is it because I think that I will have better content? Is it because I think that it's going to be a cost savings? And I just encourage everyone to undertake that analysis against the potential risks to make sure that what you're doing in terms of AI is worth the potential cost or the potential liability, or that it's meeting your needs. In other words, it is a hot thing right now and it is very common, but I just want to encourage everyone to think about whether or not it's right for your either personal use or your business use. And again, we talked about this a little bit in terms of data, because AI can go out and it can engage with consumer data. It can go out onto the internet and find text and images, all of these kinds of things. There's the potential that buried within that is something that poses a potential risk. So it's something to think about, and just making sure that whatever platform you're using or the purpose for which you're using AI is worth the risk and in line with what you truly want to accomplish. And as an extension of that, this is kind of going to the shortcomings of AI today. I think that there's a whole body of probably groups, websites, aficionados that want to try and scope out what has been made by AI and pointing out its flaws. And I think in addition to just being funny, I think it's potentially funny for some, it's helpful to know what may be created by AI, and there's a quality control component to it. If you think that you're getting a better product from AI and in actuality it's not as good of an image or work, then that's something to think about. But also making sure if you're using AI and for example, you use an AI platform to create artwork and the artwork is not really, it doesn't have a lot of the integrity that you hoped for, then that's also something to think about. And I think that as AI gets better, some of what is listed on the slide will likely become less and less of an less and less of an issue. But there are some things that you can think of, things that you can spot when you are looking for AI generated content, specifically in images or photographs. The images may lack the detail or nuance of facial expressions. If you look online, you can kind of see there's some side-by-side comparisons, and you can kind of see the images are very similar, but the actual photograph or the non-AI generated photograph has a lot more detail and complexity than the AI generated image. For videos, it may not replicate human body movements in exactly the same way as an actual human body would make them. There are also a lot of photographs that kind of don't make sense. So there was a famous photo, which some of you may have seen, where the Pope is wearing essentially streetwear and holding a cup of coffee. But if you look closely, the Pope is actually not holding the cup. There's a little bit of a divide. So these are all just things to think about when it comes to using AI and making sure that it's meeting the need or the intention of what you used it for. The other thing I will mention, and this is maybe a little bit more on the brand management side and not so much on the copyright side, but it is important. There is this notion of deep fakes, which many of you have probably encountered or heard of, and that's when you take the photograph of someone, very often a famous person like a politician, and you use AI to alter the photograph in a very negative way. So part of the issue there is just sort of the negative messaging or the negative connotation imparted by an image like that. But also those images are very often used for a negative purpose. So to encourage people to engage in a transaction that's not 100% transparent or something like that. So that's also something to be on the lookout for. And I would just say, especially for those who are involved in the marketing side or the quality control side of your business or your brand, is just like you might spot or look for infringement of your other IP, so your trademarks or your copyrighted works, you might want to add that to your repertoire of enforcement, just making sure that there aren't any fake images like that of either company shots or people in your company that may potentially do harm to your brand image or your other body of copyrighted work. And so as far as kind of shifting back a little bit to the human created requirement for copyrighted work, and I think I'm just drilling down on this concept, is that if you are seeking to protect something that has AI generated content, to be clear, in case and I think the Copyright Office really wants to drive this home, is that AI generated content is not considered the product of human authorship, especially where the human does not exercise control over how the AI essentially generates the material. So sometimes when you hear the word or see the word automated, that can be a euphemism for AI. So if the AI platform is essentially, if you tell it to create something or generate something for you, and the AI really sort of does everything for you, it just spits it out, and then you take it and include it in your work, then very often that's not going to be considered the product of human authorship, and the AI essentially handles all of, or is responsible for all of, the protectable, or what we call expressive elements of the output. So, this is a bit of a nuanced point, in that there's potentially copyright protection available for something that is involved where human authorship and AI generated content intersect. But if the human has no involvement, and this kind of goes to the human authorship portion, then it's likely not going to be protectable. So another way to say that is, as part of the human authorship component, when you have AI generated content, you want to make sure that the human has control over that AI generated content. So I would say it's very similar to when you have a work for hire situation and you have a vendor or you have a contractor who's responsible for developing your website or developing your software. Who has the ultimate control over how that work is being done? If it's the employer telling the contractor, well, do this way and do this at this time, then likely it's going to be the situation where the employer is the owner of the copyrighted work. But alternatively, if you just give the contractor very broad instructions and say, create my website, do what you will, then it's possible that the contractor, as the original author of the work, may have the copyrighted right. And that can be changed by fact and nuance, but it's something to think about. So these concepts where AI and human created content intersect are very much in line, I think, with the Copyright Office's precedents or values up until this point. And I will also say that I think most people are familiar with ChatGPT. There are also things like Recognition, which is Amazon's AI platform. There's one from Google, Lambda, but there are a host of others. And I've just listed some of these here. Most of these I've never used and have not engaged with, but some of you may have, and perhaps they're better for certain particular applications. And before I go to the slide, I think we have a poll question coming up. So, is human authorship required with applications to the US Copyright Office? And I think this is probably the one thing that I would really like to drill down on and emphasize during our time together. Because it's something that I think most people probably have not thought about. There isn't a question as to whether or not what you try to register is authored by a human, but it's definitely something to think about. And in the interest of time, I'm going to advance through these remaining slides pretty quickly. But as we give just a few more seconds to answer the poll question, I just want to say that there are circumstances where you have AI generated content that you may actually modify. And this is very similar to the transformative concept in copyrighted work. So if you are taking, yes, so to pivot to the poll questions, yes, human authorship is required. It's absolutely required for applications to the United States Copyright Office. So along those lines, you may have a work that's largely human created, but you have some portion that's created by AI technology, and you've actually modified that portion. So it's possible that that modified portion is protectable depending on what you've done, how much of that is part of the work, and how transformative it is. So it's just something to think about. And I think copyright law or copyright protection, like other aspects of intellectual property, a lot of it is fact dependent. So I guess my takeaway here is that we definitely want to emphasize human authorship, that your work has to include some elements of that, but also that's not to say that your work can't have AI generated content, but if you want protection for that, there also have to be some considerations for that, and making sure that it meets the Copyright Office's expectations for creativity. So as a practice point, in terms of filing things before the Copyright Office, I would just say make sure that you disclose what's included in your application. Just make sure that you are clear that these particular elements, sections, images, what have you, are AI generated, and also make sure you include an explanation of the human authorship contributions to your work. I think there has been an inclination up until recently to not disclose the AI generated portion of work. I think because there's a fear that your application is going to be rejected, or maybe you're going to get questions about it. But I think what the Copyright Office has shown is that they're not against registering work that includes AI content. You just have to be upfront about it and make it clear what is human created and what is AI generated. And in terms of sort of as a outgrowth of that, if you are seeking to protect work with the Copyright Office that includes AI content, and I had mentioned this before, is just making sure that you're clear on what in that work is generated by AI and what is human content, what is human generated content on your end, keeping records of that. And then also, and this is probably the last point, is really about the hygiene in terms of the use of AI, is making sure that you have policies around the use of AI, and making sure that if AI is being used, that there's someone or some structure involved to monitor that use. This is very similar to sometimes when you are in a company and people want images or something, and they go to the internet and they copy and paste something thinking it's in the public domain, and it may not be. And then you later find that you have a cease and desist letter. Very similar to that kind of IP diligence or hygiene within the company, is just making sure that you document that use of AI so that you're also not later surprised with some challenge or comment or objection from a party. So with that, I will, that ends the slide portion. There are a few questions which I'm going to try to answer One of which is, why would the work of the prompt engineer not qualify as human contribution for purposes of the Copyright Office? AI doesn't generate anything unless prompted to do so by a person. So I think to answer that question, and if I think as I understand it, why isn't the work of the engineer, in the case of the student who copied the work of the Disney illustrator, why isn't itself potentially copyrightable? And without knowing exactly what was generated, I will speak to that from the general premise of protection for copyright. One is, if you are using someone else's copyrighted work as some portion of the work that you create, certainly under copyright law, you need their permission and you need their authorization. Also, I'm not sure that what the engineer did, without looking at the specifics of what he generated, I'm not sure if he actually created something that was truly different and transformative, or he just replicated it. That's not to say that what he created is not protectable. It very well could be, but without having seen it, I think that there are some questions as to whether what he created was protectable. But it's possible. So to answer this question, it's possible that this could have been protected as its own work, but certainly if the student was to file an application, they would need to exclude the underlying portion of what he created. So if he replicated certain flourishes of the illustrator, then the underlying perhaps structures have to be excluded, but it's possible. And then the second question is, has software been developed to detect AI generated content? And maybe the listeners or the viewers know, I am not aware of something that's promoted as such, but if there isn't anything, I think that it's, I wouldn't be surprised if something like that was in the works. And it will be interesting to see how that plays out exactly, because as AI gets better, my sense is that it's going to get more and more difficult, at least to a viewer or to our own human eyeballs, to detect that. But I think that if the software kind of gets to the underlying algorithmic portion of how something was created, it's possible. But I'm not aware of anything. But if someone is aware and would like to share, please share it, and I can share it with the group after the presentation. So I think that's everything in terms of my presentation, and we are actually out of time. So we are coming up to, so I just want to say thank you for your time today. And you are now headed into your 30-minute lunch break. So when you return at 1 o'clock, you will hear from Patrick Haynes and Paul Saunders, who will present on the legal ethics for in-house counsel. So thank you for your time today.